and whether, therefore, its determination must precede the further progress of the current impeachment process. As you will recall, the Senate has previously been confronted with this question in previous impeachment proceedings. The question of what constitutes a preliminary objection was well set out in the leading case of Mukisa Biscuit Manufacturing Company Limited versus West End Distributors. And this is what, in that matter, the court held. A preliminary objection consists of a point of law which has been pleaded or which arises by clear implication out of the pleadings, and which, if argued as a preliminary point, may dispose of the suit. Examples are on the objection to the jurisdiction of the court, or a plea of the limitation or submission that the parties are bound by contract giving rise to the suit to refer the dispute to arbitration. A preliminary objection raises a pure point of law, which is argued on the assumption that all facts pleaded by the other side are correct. It cannot be raised if any fact has to be ascertained, or if what is sought is the exercise of judicial discretion. Now, honorable senators, in light of this similar decision, it is now well settled and established in our practice that a preliminary objection does not require evidence to be adduced as proof of its existence. It is limited to points of law and cannot be raised if a fact has to be ascertained by the use of evidence to be adduced. Reference has been variously made by counsel for the governor and counsel for the county assembly to the jurisprudence that has been laid down by this House in the two Kericho impeachment matters, now commonly referred to as Kericho 1 and Kericho 2, in which the Senate arrived at different conclusions on the nature of preliminary objection and the appropriate place at which to make a determination. In fact, there was no contradiction in the determinations made by this House in Kericho 1 and Kericho 2. In Kericho 1, the Senate determined that a classical preliminary objection was one which is purely a matter of law and which required no evidence to be adduced for its determination. In that case, it was not in contention that the number of county assembly members who had voted in support of the impeachment motion was 31. It was also not in contention that the total number of Kericho County Assembly members was 47. The only question was whether 31 members constituted the two-thirds threshold as required by law. In Kericho 2, on the other hand, the question was whether some of the County Assembly members alleged to have voted in support of the motion did